So let's talk about trademark strength. When you're advising a client, when your client comes to you and says, hey, I want to trademark this game name, you need to be able to analyze how strong their trademark is and advise them on maybe making it stronger if need be. So there's basically 5 levels of distinctiveness. Distinctiveness is what gives trademarks their strength. Because they're identifying the source of goods, they have to be distinctive from other things and from the product itself, right? So if you had a game called Game, that's not very distinctive, right? And we'll get to that. That's a generic mark. But the 2 strongest ones of the 5 are arbitrary and fanciful marks. So arbitrary marks are basically when you use a term that has nothing to do with the product itself. A good example is Apple. Apple is a very strong trademark, and you may be thinking, well, it's just a common word. How can you protect that? If I was selling apples and calling my company Apple, then that would be a problem because that's not distinctive at all. I'm basically just describing my goods. However, if I'm selling computers and I'm calling myself Apple, that's very strong because there's a huge disconnect between the thing that I'm selling and the name that I'm using. And that's why Apple is such a strong trademark. So marks like that are very strong, and that's definitely where you want to push towards. Fanciful marks are words that are invented solely for their use as trademarks. So good examples are Exxon or Xerox, right? Or even in the game space, there's a game called Zaxxon, right? And so if you called that, if your client came to you and said, hey, we want to make a game called Space Shooter, right? That's not very that's very descriptive of what the actual game is, and it's not a very good trademark. However, you call your game Zaxxon, and it's very distinctive. There aren't any other games named that. That's the kind of mark you're going to go for. The next lower level is what's called suggestive marks. So these are marks like Microsoft or Blu-ray. Now Blu-ray, they require some sort of jump in logic between the mark and the actual product. So for Blu-ray, the name is describing the blue laser that's within the thing that reads the disc, but the disc itself, you call that Blu-ray, and there's sort of that leap in logic that you need to do. So these are also strong. These are trademarkable. You can go and register these, no problem. They call them inherently distinctive. So by themselves, because they're just suggestive of the product, they are inherently distinctive, as opposed to descriptive marks, which are not inherently distinctive and which require a little bit more in order to be registered. So if you took a descriptive mark like Windows or World Book for encyclopedias, I mean, World Book, it's a book that talks about the world, right? I mean, it's describing the product. It's not a good trademark. You need to prove what's called secondary meaning in order to show that this is distinctive enough and to be able to register it. Basically, you're going to have to show that your customers identify this trademark with your goods specifically. And so you can do that through surveys and other maybe online information. But otherwise, without that secondary meaning, you're not going to be able to register those trademarks. So you want to steer clients away from marks that just describe. And I think the example I used before where you call a space shooting game, space shooter, is more of a descriptive mark. The worst ones are generic marks. So things like email or multi-state bar exam, which I'm sure everyone's familiar with. That is a terrible mark because it's basically just describing the exact product that there is. So the generic term is unprotectable, and a good example from the past is one called escalators. So we all ride up escalators, right? You don't think of escalator as a brand name, you think of it as a thing because it's become generic over time. It started off as a specific brand name and then became just a thing that that you ride. And so that's called genericide, right? It basically kills your trademark. One that might be in danger of that modernly is Google. So when you talk about Googling something, right, you're not necessarily talking about typing something into Google, you're talking about just sort of doing a web search for something. So Google has to fight against that or else they're going to lose any rights they may have had. One example of fighting against that is Band-Aids. So Band-Aids, in all their advertisement, they call themselves Band-Aid brand bandages, right? Because otherwise, if the word Band-Aid becomes synonymous with those bandages, then they're going to lose their trademark rights, which they don't want to do. So this highlights the need to keep policing your brand and making sure that it remains distinctive. It's not a huge issue for video games yet, but it may in time. So when your client comes to you with a trademark, you're going to have to do a trademark search to make sure that it doesn't conflict with other marks. And this is a super important part of the process. Generally, I include this as part of my trademark flat fee service. I search the USPTO's database, and you want to search for, you want to look in plural and singular versions of the name, maybe the same root word, different spellings of their proposed mark. You want to do a bunch of different searches to try and find the conflicting marks or things that could potentially be conflicting, because you may want to avoid that. Search the EU. The EU has a trademark database that you can look through. Search EU community trademarks. And if you plan on releasing in other countries, you may want to check and see if they have a specific database to that country. Search also, I go onto Google and I just type in the proposed name and see, and maybe the proposed name and game or a game company or something like that, just to see and search 5 or 10 pages deep to see if there's anything else that's conflicting out there. I think that's a hugely important search tool, because a lot of game companies will release a game, but they don't actually register a trademark. So just because there's no registration doesn't mean that they don't have rights, because the rights come from actual usage. There are also industry-specific search engines. So if you're going to be releasing an app in the Google Play Store or the Apple App Store, you want to go on those stores and search for some variations of your proposed trademark. So when I give a client a trademark questionnaire, I'll generally ask for 5 to 10 names that they propose. Clients all hate that. They all have one name that they really want. But that's a mistake. If you go with one name, if there's a conflict with that name, then you basically have to go back to the drawing board, or you have to risk having your trademark refused or getting sued by that other trademark holder. You basically go through those 5 or 10 names, and off the bat you eliminate anything that isn't at least suggestive or strong trademarks, right? So get rid of any descriptive or generic type trademarks, anything that's not the strongest. You could even get rid of suggestive if you really want to, and just keep the arbitrary and fanciful ones. I try to push them toward those, making up a new word for the game, which is the best. And then the ones that are left over, this is called a knockout search, by the way. That's what they call it, because you're knocking out the potential conflicts. Then go through and do those searches that I just talked about in the last slide. Search the USPTO, search the EU, search Google, and try and find conflicting marks that are out there, and narrow down the list to 1 or 2, and report back to your client.